Today, we are going to discuss UN Convention on Prevention and Punishment of Crimes and Genocide, 1951. To start with, the understanding of genocide and lessons from history. Crime against humanity is not something that occurs only in peacetime. The history of experiencing crime that would amount to the intensity of what we call genocide today has a long history. It was with this idea in mind the pioneers of UN acknowledged the danger of genocide as having inflicted great losses on humanity. The bitter memories left by the two world wars of the 20th century and the emergence of some notorious and oppressive regimes in the form of imperialism and Nazism had completely jeopardized rights of the colonized and minorities. In the case of Nazism, it was poised to wipe out the Poles, the Russians, the Slovenians in Carniola and in Carinthia with objectives to cause demographic and cultural destruction. Aptly describing the Nazi brutality during the Second World War, Winston Churchill said in his broadcast of August 1941, I quote, "We are in the presence of a crime without a name," unquote. The statement could be understood as a part of the larger international concern to do away with communal politics and grave crime against humanity. The environment was gradually set to arrive at an appropriate terminology to define grave crimes. In the words of Raphael Lemkin, the name that floated around to define the phenomenon was hinted to as something like mass murder. By its very legal, moral and humanitarian nature, it must be considered as an international crime. With this background in mind, we can discuss UN on genocide and the emergence of a legal system. At the first session of the General Assembly in the late 1946, a draft proposal was worked out with two crucial objectives. First, the need for a UN declaration to treat genocide as a crime that could be committed in peacetime as well as in the time of war. And second, to bring in genocide cases under the international juridical system. The draft proposal was positively responded by the General Assembly in December 1946. The text of the Convention for the Prevention and Punishment of the Crime and Genocide was adopted by the United Nations General Assembly on 9 December 1948. After obtaining the requisite 20 ratifications required, according to Article 13, the Convention entered into force on 12 January 1951. The significance of 1951 Convention is underlined in the advisory opinion of the International Court of Justice, 28 May 1951. As it remarked, I quote, "The principles underlying the Convention are recognized by civilized nations as binding on states even without any conventional obligation." It was intended that the Convention would be universal in scope. Its purpose is purely humanitarian and civilizing, I unquote. It was against these backdrops of growing global understanding, several other specialized instruments to protect human rights were conceived one after another. To cite some examples, the International Covenant on Civil and Political Rights, also known as ICCPR, is a multilateral treaty adopted by the United Nations General Assembly on 16 December 1966 and in force from March 23, 1976. It commits its parties to respect the civil and political rights of individuals, including the right to life, freedom of religion, freedom of speech, freedom of assembly, electoral rights, and fair trial. As of May 2013, the Covenant had 74 signatories and 167 parties. The ICCPR can also be understood as a part of the Declaration on the Granting of Independence to Colonial Countries and Peoples, International Bill of Human Rights, along with the International Covenant on Economic, Social and Cultural Rights, also known as ICESCR, and the Universal Declaration of Human Rights, UDHR. It would not be wrong to argue that 1951 Convention on Genocide evolved to become a customary responsibility for member states of the UN. Friends, now we will discuss UN Convention on Genocide of 1951 in the context of its legal commitments. Article 1 provides the important clarification that genocide can be committed in time of peace or in time of war. According to Article 1, genocide is a crime of intentional destruction of a national, ethnic, racial and religious group, in the whole or in part. Further, Article 2 lays out loud and clear, as it argues, in the present convention, genocide means any of the following acts: A. Killing. B. Causing bodily or mental harm. C. Deliberately inflicting on a group life, bringing about its destruction in whole or in part. D. Imposing measures intended to prevent births within the group. E. Forcibly transferring children of a group to another. According to Article 3 and 4, several acts that constitute criminality would be punishable, including genocide, conspiracy to commit genocide, incitement to commit genocide, and to show complicity in cases of genocide. Article 5 is highly interesting as it directs a state to constitutionally uphold world's fight against genocide and to initiate necessary legislation in this regard. Whereas it remains questionable if contracting states have practically fulfilled these directions of UN. Article 6 recognizes only territorial jurisdiction as well as jurisdiction of an international criminal tribunal. This was the beginning of a sporadic work that would eventually lead half a century later to the adoption of Rome Statute of International Criminal Court, which is enshrined in the Article 7. Now we will also discuss about the status of India in the context of 1951 Convention. India is one of the states that ratified the Convention of 1951. Having signed and ratified the Convention, India's responsibility to protect its citizens against any genocidal crimes become important. The ratification of the Convention can be discussed in the light of Article 253 of the Constitution of India. Article 253 reads, I quote, "The Parliament has the power to make any law for the whole or any part of the territory of India for implementing treaty, agreement, or convention with any other country or countries or any decision made at any international conference, association, or other body." In the wake of the intensified armed movements in Kashmir, the Hindu-Muslim relations in Kashmir got strained by the year 1989. As a result, the Hindus in Kashmir were targeted by the insurgents, causing massive displacement of Kashmiri Hindus, also called as Kashmiri Pandits. In the opinion of the National Human Rights Commission of India on June 11, 1999, in a ruling stated that, I quote, "The crimes against the Kashmiri Pandits are near genocide and not genocide," unquote. On the other hand, there are serious issues of states' excesses as far as counterinsurgency operations as experienced in the northeast India, Kashmir and Punjab is concerned. India's response to ensure comfort and justice from the perspective of minorities has run short of victims' aspirations. India's constitutional commitment to preempt genocidal practices are in principle laid out in several sections of the Constitution, such as the Article 14, that makes everyone equal, irrespective of any social background. According to Directive Principles of State Policy, Article 51, the Constitution gives political and legal equality the status of a fundamental right, economic and social equality. If one goes by the legal spirit of Article 21 of India's Constitution, protection of life and liberty are to be ensured. Interestingly, the word genocide has been used in some of the Supreme Court judgments in India. In the state of UP versus Ram, Sajivan and others, the Supreme Court in its judgment on 4th December 2009 used the term genocide to describe the seriousness of multiple murder of 7 lower caste Harijans committed by upper caste. Now let us look at some UN interventions. It is not only in India, the question of securing rights of people are often left potentially open to violations, but also there are a plethora of similar and even more complicated violations of similar kind. To talk about the history of breaching the Convention of 1951, the following cases can be mentioned as a part of UN's success stories. To begin with Rwandan Case, fighting between the armed forces of the mainly Hutu government of Rwanda and Tutsi-led Rwandanese Patriotic Front, also known as RPF, first broke out in October 1990 across the border between Rwanda and its northern neighbor, Uganda. The Security Council in June 1993 established the United Nations Observer Mission Uganda and Rwanda. On 8 November 1994, the Security Council established the International Tribunal for Rwanda with the objective, I quote, "for the sole purpose of prosecuting persons responsible for genocide and other serious violations of international humanitarian law committed in the territory of Rwanda and Rwandan citizens responsible for genocide," unquote. Between 1st January 1994 and 31st December 1994. After a rigorous trial in the International Criminal Tribunal for Rwanda, on 2nd September 1998, former officials were punished for genocide-related crimes. In the Cambodian case, a special tribunal was set up in 2013 to try those accused of genocide, war crimes and crime against humanity during Khmer Rouge regime in Cambodia between 1975 and 1979. The extraordinary chambers in the courts of Cambodia, established as a result of an agreement between the UN and Cambodian government in February 2012, sentenced Kaing Guek Ev, the former head of a notorious detention camp, to life in prison, the maximum sentence under Cambodian law for crime against humanity and grave breaches of 1949 Geneva Conventions. Let us also talk about Libyan case. In the case of Libya, the international community moved quickly to stop the government from killing its own citizens. UN Security Council Resolution number 1973 in March 2011 enabled an international coalition to intervene to stop the killings of protesters of Gaddafi regime. We will also talk about an achievement of UN in the context of the establishment of a warning system to prevent genocide. The tragedies of Rwanda and the Balkans and elsewhere in the 1990s demonstrated in the worst possible way that the international community had to do more to prevent genocide. With this in mind, the Secretary General in 2004 appointed Juan Mendes as Special Advisor on the Prevention of Genocide, succeeded by Francis Deng and by Adama Dieng. The Special Advisor collects information on situations where there may be a risk of genocide, war crimes, ethnic cleansing, and crime against humanity. To conclude, today, the gaps left by somewhat narrow definition of genocide in the 1951 Convention have been filled more or less satisfactorily by the dramatic enlargement of the ambit of crime against humanity during the 1990s. The coverage of crime against humanity expanded to include acts perpetrated in time of peace and to a broad range of groups, not to mention an ever-growing list of punishable acts inspired by developments in international human rights law, particularly addressing physical destruction of a group or community or a race. The Genocide Convention was the first human rights treaty adopted by the General Assembly of the United Nations in order to protect national, racial, ethnic, and religious minorities from threats to their very existence. It is with this perspective the Convention on Genocide provides the much-needed foundation to the priorities of UN international commitment to protect human rights, while at the same time aiming at the complete eradication of racism and xenophobia. The Convention stresses the role and importance of criminal justice and member states' accountability in the protection and promotion of human rights all over the world. Now, the onus is on the part of the member states, particularly those who have agreed to abide by the spirit and principles of the Convention. However, the world has seen enough of state excesses, violence, subjugation, and ethnicization of community relations, which continue to breed politics of oppression, hatred, and crime. The Convention of 1951, if taken seriously in the world of international diplomacy, could serve as a strong point for global peace, harmony, and security of peoples.